To give you a small brief about today's session, we are going to use a PPT to understand the concept. And what I have done is, because we are generally going to, get an overview of the two doctrines, I have kept a small break between the two so that we can, address the questions relating to that doctrine and then move ahead. So we can either go that way, or in the end of the session, as ma'am said, I would love to address your questions even then. So that being said, let us begin. As you know, Article 13 is the one which we would be concentrating on today. So आज का roadmap देख लेते हैं, how we will be going about it. So see, for today, what we are going to do is we will focus on Article 13 and we will try to first get an overview कि Article 13 है क्या, what is the bare text of Article 13, and then we will see Doctrine of Eclipse, which is a part of Article 13, as well as Doctrine of Severability. और ये दोनों करते हुए whatever important case laws we feel is important on the way, we will try to cover those. So that being said, let us start. Would anybody like to volunteer? This is Article 13 of the Constitution.
Article 13 of the Constitution. Laws inconsistent with or in derogation of the fundamental rights. All laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. 2. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. 3. In this article, unless the context otherwise requires, A law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. B. Laws in force includes laws passed or made by a legislature or other competent authority in the territory of India before the commencement of this Constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas. Laws inconsistent with or in derogation of the fundamental rights. Nothing in this article shall apply to any amendment of this Constitution made under Article 368.
So basically ये जो Article 13 है, this is the article जिसके ऊपर हमारी दोनों भी doctrine based है, and what we are going to focus on today is the first two clauses. That is the all laws in force and territory. We'll see both these clauses one by one. But I wanted to let you know what Article 13 entails entirely, because इसके आगे के भी जो दो clauses है, even though they are not related to the doctrine we'll be studying today, this is the entire article, and together it tells us a lot of other important things as well. जैसे कि clause 3 और clause 4 को एकदम briefly if we see, it tells us what does law include. Because when you are saying something that ये law ऐसा होना चाहिए, this law should not be inconsistent with the fundamental rights. So you should also be able to identify which laws are we talking about. That is why it has been defined. Second, laws in force has been defined. और जो clause 4 है, it is basically just talking about that anything, nothing in this article shall apply to any amendment of the Constitution made under Article 368. So it is talking about the amendment procedure which has been given in Article 368, and it is making a distinction कि यहाँ पे जो भी हम amendments की बात कर रहे हैं, या तो ये जो भी article जिस चीज की बात कर रहा है, this will not be applicable to any of the amendments. So this was clause 3 and 4. What we will be focusing upon is clause 1 and clause 2 for the purposes of Doctrine of Eclipse and Doctrine of Severability. So let us first see clause 1. Let us decode clause 1. What it basically tells us is all laws in force in the territory of India immediately before the commencement of this Constitution. So can anyone put it in the chat box? Which laws are we talking about? Are we talking about post-constitutional laws, or are we talking about pre-constitutional laws? Pre-constitutional laws, everybody is on the same page, because हम किसकी बात कर रहे हैं? Immediately before the commencement of the Constitution. So laws in force, as I told you, कि जो clause 3 है, it is defining what are laws in force. So that is why that clause itself is also very important, क्योंकि यहाँ पे we are talking about laws in force. But what are they is something which has been defined in clause 3 of Article 13. Right? So यहाँ पे since it says immediately before the commencement of this Constitution, it is talking about pre pre-constitutional laws. Excuse my handwriting. And it says, insofar as they are inconsistent with the provisions of this part 3, because fundamental rights have been dealt in part 3 of the Constitution, shall, to the extent of such inconsistency, be void. So it is not talking about the whole provision, it is talking about certain part of it, and that we'll see in detail in the Doctrine of Severability. Before that, let us quickly have a small exercise, and can anybody unmute or put it in the chat box and tell me what can you see on your screen right now? What is this picture? What does it depict? So this is basically an eclipse, right? Everybody on the same page, it's an eclipse. This yahan pe you can take into consideration either solar eclipse, lunar eclipse, and have that thing in your head, and then we move ahead with the Doctrine of Eclipse. So basically, as you can see in this picture, the sun is behind, and then there is this small or the circular line which has been formed because of the shadow which has been made through moon. So if you're considering solar eclipse for the example, this is what you keep in mind, and we move ahead. So now this thing we are going to apply to the law and understand how Doctrine of Eclipse works in relation to laws. तो यहाँ पे normal eclipse तो हमको समझ में आ गया कि पीछे for instance if it's a solar eclipse there is sun, and because of the positioning of the moon what we see is a small line or the circular line which is left, and the sun is basically overshadowed by the moon, right? तो ये ध्यान में रखते हुए let us apply this to the laws. So basically this is exactly what Doctrine of Eclipse also tells us. तो यहाँ पे जो हमारा pre-constitutional laws है, since we read that all of this is applicable to what? The laws which were there before the commencement of the constitution. Those are our pre-constitutional laws, right? तो यहाँ पे what had happened is, for instance, अगर हमको हमारा independence समझो 1947 में मिला, our constitution was enacted in 1949, then it was commenced in 1950, but prior to this, didn't we already have laws, right? If I take example of Indian Penal Code, that code is of 1860 itself, right? So it was not the case कि independence से पहले या constitution के commence होने से पहले we did not have any laws, and it would not be rational to just say कि यार सारे जो laws हैं हम उनको repeal कर देते हैं and we'll start making a fresh laws from the commencement of the constitution. That would not have been a very rational thing to do, because these laws they already existed और इसकी वजह से काफी कुछ हमारे society में already structure था. And the very fact that it was working because these laws were applicable and everything was in place. So there was no problem with most of them. So what we did is, rather than saying कि हम सारे जो laws हैं उनको repeal कर देंगे, we applied the Doctrine of Eclipse, and this is only with respect to clause 1 of Article 13. I'll go back to that slide. See. It tells us immediately before the commencement of this constitution. So ये जो Article 13 clause 1 है, only this clause is talking about the laws which are basically existing before the commencement of the constitution, right? So यहाँ पे pre-constitutional laws के बारे में बात कर रहे हैं, and this is how the courts have also interpreted that what are we going to do about these laws which were there before the commencement of the constitution. So this is what it does. So जो भी pre-constitutional laws थे, what it was basically said is कि जो भी laws है, we will keep them. We will not say कि they are repealed. We will not hold them void. We will not say that they are repealed or something like that. We will keep them. But if fundamental rights ये कब हमारे introduce हुए? जो constitution आया तब fundamental rights है, तब part 3 enforce हुआ. So what it was said is that we will keep the pre-constitutional laws and we will put a shadow of the fundamental rights. So in case there are any laws which are violating the fundamental rights of the country, उसको हम fundamental rights से overshadow कर देंगे, but at the same time ये जो laws है they are going to still be there, and they are going to be there as dormant or sleeping provisions. So for instance, if there is some we will take case laws for example, and you will understand which provisions we are dealing with, but basically ये होता है कि it's basically kept in a dormant and sleeping state so that you are able to keep them. और जब ये जो shadow है, फॉर इंस्टेंस यहाँ पे हमारा कोई अमेंडमेंट आ गया फंडामेंटल राइट में, जिसके वर्च्यू से जो पहले वायलेट हो रहा था फंडामेंटल राइट वो अब नहीं हो रहा है, ठीक है? इफ दैट सिचुएशन अकर्स वी विल मेक दीज प्रोविजंस इन्फोर्सेबल, ठीक है? ये इन्फोर्सेबल हो जाएंगे और इसका जो भी शैडो था, वट एवर इम्पेडिमेंट वाज देयर, if that is removed, these laws will become enforceable. And for instance, वापस से ऐसे कुछ law आ गया, वापस से हमारा कोई fundamental right आ गया जिसके through again there has been some violation. There is some pre-constitutional law, there has again been some violation. If that occurs, again the shadow will come. ठीक है. सो जो भी शैडो आएगा दैट विल बेसिकली मेक श्योर कि जो भी प्री कॉन्स्टिट्यूशनल लॉ है अगर वो वायलेट कर रहा है फंडामेंटल राइट्स को, दैट विल रिमेन इन अ स्लीपिंग पोजीशन, इट विल नॉट बी इन्फोर्सेबल बाय लॉ. सो फर्स्ट ऑफ ऑल 3 पॉइंट्स वी विल जस्ट कीप इन माइंड फॉर डॉक्ट्रिन ऑफ एक्लिप्स. ये तो हमको बहुत क्लियर हो गया कि दिस इज ओनली एप्लीकेबल टू व्हाट, प्री कॉन्स्टिट्यूशनल लॉज. वी आर नॉट टॉकिंग अबाउट पोस्ट कॉन्स्टिट्यूशनल लॉज. And if you apply this logically, why is it only applicable to pre-constitutional laws? Why is it not applicable to post-constitutional laws? It is very logical. क्योंकि अगर हमारा fundamental rights 1950 से समझो अगर हमने commence कर लिया constitution and fundamental rights have been enforced, then any new laws which are coming वो post-constitutional laws हो गए. These laws obviously they cannot violate fundamental rights. अगर वो कर रहे थे violate fundamental rights को, they would be void from the very beginning. तो ये eclipse का question ही नहीं आता है, because at this point constitution was already in place, fundamental rights are already in place, part 3 भी already हमारे पास है. तो अगर part 3 already exists, it is not possible that a law comes into picture which is violating fundamental rights, है ना. जो भी हमारा पार्लियामेंट है वो ऐसे लॉज लाएगा ही नहीं जो फंडामेंटल राइट को अब्रिज कर रहे हैं. इन केस दे डू गेट, देन द एंटायर प्रोसीजर ऑब्वियसली एग्जिस्ट कि आप जाके कोर्ट में इन्फोर्स करा सकते हो फंडामेंटल राइट एक्सेट्रा. बट ऑलवेज अ प्रिजम्पशन ऑफ कॉन्स्टिट्यूशनैलिटी तो रहेगा that whatever these rights are or whatever this law is, it is going to be constitutionally valid. So that is the reason it is only applicable to pre-constitutional laws. Secondly, provisions are overshadowed by fundamental rights and become unenforceable. तो ये void नहीं हो जाते, they will still be there, they will be in a dormant position, और basically जब भी ये impediment हट जाएगा तब हम वापस से वो लॉज को इन्फोर्स कर सकते हैं. बट अंटिल द शैडो ऑफ फंडामेंटल राइट्स एग्जिस्ट, दीज प्रोविजंस विल बी अनएन्फोर्सेबल एंड यू कैन नॉट गो एंड एन्फोर्स देम इन द कोर्ट. Last point is, such laws are not wiped out entirely. अगर एक कोई फॉर इंस्टेंस इफ देयर इज अ लॉ, ओके, बेरार मोटर व्हीकल का एग्जांपल हम लोग आगे भी लेंगे. इफ दिस लॉ वाज देयर, ओके, एंड देयर वाज सर्टेन प्रोविजंस इसमें से जो वायलेट कर रहे हैं फंडामेंटल राइट, so those provision for the time being will become unenforceable, but ये wipe out नहीं हो जाएंगे statute में से. This statute will still be in place unless it is expressly repealed. It's in another situation, it's an exception, but otherwise all pre-constitutional laws basically will exist the way they are, but the only thing is वो unenforceable हो जाएंगे, and the reason is that it is basically overshadowed by the fundamental rights. ठीक है. Now let us see the case of Bikaji versus State of Madhya Pradesh. It's a 1955 judgment of the Supreme Court, and it very well explains the doctrine of eclipse. And the way to go about it would be कि आप इसकी timeline देखो. सबसे पहले हम 1948 से चालू कर रहे हैं. That makes it a pre-constitutional law. The Berar Motor Vehicles Amendment Act, which was passed in the year 1948, यहाँ पे state government authorized to take up the entire motor transport business, and it allowed to exclude motor transport operators. तो basically ये क्या कर रहा था, ये monopoly दे रहा था to whom? To the state governments. So till 1948 हमारे fundamental rights थे नहीं, हमारा constitution था नहीं. So this was basically a valid piece of legislation. ठीक है, there was no problem with this, and all the provisions were basically enforceable. अब 1950 में हमारा आर्टिकल 19 क्लॉज 1 जी आ जाता है, which is the right to practice any profession or to carry on any occupation, trade or business. अब because we have this fundamental right, this law, the provision specifically which was authorizing the state government to take up the entire motor transport business, basically जो भी monopoly allow हो रही थी, whichever provisions were talking about that, they were overshadowed by 19(1) clause G. क्योंकि यहाँ पे अब the citizens also had the right to practice any profession, और यहाँ पे monopoly का नहीं कुछ भी mention किया गया था. So because this fundamental right came into picture in 1950, जो 1948 का जो ये law था वो overshadow हो गया. ठीक है. So now उसके बाद क्या हुआ, 1948 हो गया, 1950 हो गया. Then in the year 1951, okay, now this is 1 year after the commencement of the constitution, clause 6 जो था उसको amend किया गया. So basically if you see article 19, हर क्लॉज के साथ एक रीजनेबल एक्सेप्शन है. सो इफ यू सी 19(1)(g है तो वो 19(1)(1) से जो भी क्लॉज 1 होगा उसका एक्सेप्शन, इट विल मेंशन दैट दिस इज द एक्सेप्शन एंड दिस इज हाउ इट इज गोइंग टू बी प्रैक्टिस द होल फंडामेंटल राइट अलोंग विद द रीजनेबल एक्सेप्शन. तो यहाँ पे जो 19(1)(g था उसके लिए उसका पैरेलल क्लॉज 6 आया, 19 क्लॉज 6, that basically was amended. और अब amendment के बाद ये हुआ that the government was authorized to monopolize any business. So if you see the existing article 19 clause 6, this is exactly what it says, that you are basically authorized to monopolize any business. Who is authorized? The state government or the government in general. उनको ये पावर दे दिया गया था. अब if you can basically say जो 1948 में हो रहा था, that is also the same thing. The Berar Motor Vehicles Act was also kind of telling the same thing कि state government जो है उसको हम authorize करेंगे to take up the entire motor transport business. So this जो 1950 का इसको हम impediment कह सकते हैं कि यहाँ पे because this feature or this fundamental right came into picture, ये जो है वो overshadow हो गया था. But now since because of the amendment, ये एक amendment आ गया 19 clause 6 का. Now because that is done, now you can say that the impediment has been removed. So let us apply this in the picture which we referred to. तो आप ये कह सकते हो कि जो आर्टिकल 19 क्लॉज 1(g) था ये हमारा फंडामेंटल राइट था, ठीक है. ये जो फंडामेंटल राइट था, दिस वाज ओवरशैडोइंग और दिस वाज बेसिकली शैडोइंग द प्रोविजंस ऑफ द बेरार मोटर व्हीकल एक्ट, जो भी ये मोनोपोली अलाउ कर रहे थे. बट बिकॉज 19(6) जो है 19 क्लॉज 6 आया, the impediment because of this amendment, the impediment, this shadow जो है ये पूरा हट गया. So these provisions, the light which is there, which were the provisions of the Berar Motor Vehicles Act, they came into picture और अब ये enforceable हो गए. So this was a very good example as to how Doctrine of Eclipse works. So it also tells you कि अगर in future कभी ये impediment हट जाता है, at that particular time the provisions will again become enforceable. That is the very reasoning behind keeping them as sleeping provisions and not repealing them altogether. So this was in general Doctrine of Eclipse.
I just wanted to also know that from what you said is that the Doctrine of Eclipse would also pertain, you mentioned that it would be sleeping, right? So at any, I mean, given that, the fundamental rights chapter exists, then can it be, is it only a sleeping thing or can it be, argued later?
No, so see how it works is that other part, like for instance, part 3 came into picture in the year 1950 because our constitution was commenced then, right? So all these laws which were already existing back then, now it will always be possible, right? There are, like for instance, there are motor vehicle example which we saw. So ये जो legislation था, this was already there in the year 1948. Now, when the constitution is commenced, you will have a clear picture which laws are violating fundamental rights, right? Because we already have part 3 in place. Whatever amendments are going to come, in future it's going to happen. Like how in the same example, there was an amendment for which the entire shadow was removed and this provision became enforceable. So at any given point, you will always know कि कौन सा provision है जो fundamental rights को violate कर रहा है. And because fundamental rights are going to be concrete at any given point, you can always say which provision or which pre-constitutional law is violating the same. So we are not repealing the same unless, there is an explicit decision of the court that, this law itself is very, like for instance, 377, when we held that to be unconstitutional. So it was basically now, even though it is a pre-constitutional law, it does not exist, right? So that is an explicit decision of the court. But at the same time, agar ye cheez, when it was already existing and we had a fundamental right we did not have actually any fundamental right. But for instance, we had a fundamental right which said that you can't discriminate basically on any gender in relation to the LGBTQ community, tab wo वापस से sleeping provision में चले जाता. And then if you had made any amendment to it, and then again it would have been enforced. So these are two aspects. The court will always function the way they do if they find something unconstitutional. But to answer your question, at any given point, you will always know which provisions are violating the fundamental rights. So you can always consider them to be dormant provisions.
Okay.
If that answers your question.
Yes. Yeah. Thank you. So I imagine there are other provisions that obviously exist, which are still to be declared, in contradiction to the fundamental rights.
Correct. So actually, the only thing is, even if right now, even if you don't declare it, for instance, there are all because obviously I understand your query that you can't always declare that these are the sleeping provisions. That is why the point of enforceability comes into picture. Abhi Berar provision, like the Berar Motor Vehicles Act, even though it was not declared that this provision is unconstitutional, had someone gone and tried to enforce that right, the court would obviously say that ये fundamental right exists करता है, and that is why this said provision is not enforceable. So at that particular junction, whenever you try to enforce that particular right, that junction obviously you will be stopped. So it's not the case, even though it's not explicitly mentioned कि कौन से violate कर रहे हैं, but you at the same time you can't enforce it, right? You can't go to the court and say you enforce my this right, and even though a contradictory fundamental right exists. So that being said, that is where how that is taken care of.
Just to clarify, eclipse is totally different than repealing. That is, repealing means the law going away altogether.
Right, definitely. So repealing, so as we took an example of section 377, that has been basically struck down by the court, right? Or agar repeal ki baat karoge, if there is an amendment and that says that the previous law has been repealed, that's an entirely different thing. That no longer remains as sleeping or dormant provision. They are basically struck out. So abhi yahan pe at any point there won't, unless there's an amendment, jo वापस से same चीज introduce कर रहा है, unless that is done, those laws are not there at all. So it's not the case कि कोई एक fundamental right amend hoga and there will be some sort of different thing and now it will be enforceable. That won't happen. And also keep in mind, we are talking about pre-constitutional laws. So हमारे mind में जो भी questions आते हैं ना कि अभी अगर amendment आया तो वो, all that is for post-constitutional laws. जैसे Juvenile Justice Act has been amended recently, or the 2015 amendment. All of that is happening post-constitutionally. So it's not happening pre-constitutionally. So that is why जो repeal का part है, that will work for our post-constitutional laws, even for pre-constitutional laws. But the repeal part is definitely different than your sleeping provisions. Now, what I want you to, so obviously, हमने Article 13, Clause 1, you've already seen this article. Now we are going to read it again and we are going to try to focus on few terms for Article 3, Clause 1 as well as Article 13, Clause 2. Sorry, 13, not 3. So यहाँ पे all laws enforced in the territory of India immediately before the commencement. यहाँ पे pre की भी बात हो रही है insofar as they are inconsistent. So basically, to the extent of such inconsistency, the reason why I have highlighted this is यहाँ पे we are not talking about an entire law, an entire statute, or an entire provision for that matter. We are talking about to the extent of such inconsistency means कि हम कोई एक पर्टिकुलर पार्ट के बारे में बात कर रहे हैं. वी आर नॉट सेइंग दैट फॉर इंस्टेंस अगर ये इनवैलिड है तो बाकी भी चीजें इनवैलिड, और वी आर नॉट टॉकिंग अबाउट एन एंटायर स्टैट्यूट इन द फर्स्ट प्लेस. सो यू कीप इन माइंड दीज वर्ड्स to the extent of such inconsistency. And अब ये clause 2 जो है article 13 का, that also says the state shall not make any law which takes away or abridges the rights conferred by this part. तो ये part 3 हो गया हमारा. And any law made in contravention of this clause to the extent of the contravention be void. So these two terms, यहाँ पे to the extent of such inconsistency and to the extent of the contravention, this you keep in mind, and then we move ahead with a short exercise. So madam, what do you see on your screen right now? What is the image?
I see a basket.
Correct. So it's a vegetable basket. Are you going to throw any portion out of it? On the looks of it, it looks like a proper good vegetable basket, right? Anything seems rotten to you?
No, so not that I can see.
Right. So you're not going to throw anything out of it. We can assume that?
Yes.
Okay. Now, you're not going to throw anything out of it. That is what we have all come on the same page with. Ab yahan pe you find out, when you turn the basket, you find out that okay, this particular carrot which was behind, that seems to be rotten. Okay.
Right.
Now in this scenario, what are you going to do? Are you going to throw the entire vegetable basket? Are you going to remove the carrot out of it, or are you going to do something else? Can you tell us?
Remove the carrot out of the basket.
Very well. So what we are doing is, we are not throwing the entire fruit basket. We are going to remove that particular vegetable which was rotten. Now, just one last example. This is a rotten apple, right? Now, do you think any part of this can be severed and can be consumed?
No. If the worm has infested it to, depending on the degree, then of course one might have to throw the entire apple out.
Exactly, because now if you see the worm and everything, we are not even sure, till what extent inside is it an edible, and that is why, as a rational human, we will try not to consume this apple for the very reason it does not seem edible anymore. right?
Right.
So
Right.
we are going to throw the entire apple out. This how everybody is on the same page with this, the two examples, right? We will now move on to the doctrine of severability. These were the few answers which I was requiring from your end, and that exactly was doctrine of severability. So what doctrine of severability tells us is, we'll go back to the examples once again, but you need to understand two things. First of all, whole act is not invalid by being inconsistent with part 3 of the constitution. Part 3 हमारा fundamental rights, okay? Fundamental rights is dealt in part 3. What it says is, the whole act will not be invalid by being inconsistent with the part 3 of the constitution. Only such provisions of it which are violative of fundamental rights will be invalid. Let us go back to our example. Now यहाँ पे the whole fruit basket was not in the example, as Deepa madam told us, just because the carrot has been rotten does not mean I will throw the entire vegetable basket. So this was the point 1. Now moving on to point 2, it says valid portion. If the valid portion is so closely mixed up with the invalid portion that it cannot be separated, the court will declare the entire act void. This is exactly what the apple example is. Even though we see कि यहाँ थोड़ा portion तो है, we can try and see if we can cut and remove the portion, but it is so mixed. Like if you see यहाँ से भी there is an infection, there's a worm here, it's rotten over here. It is so closely mixed up with this small valid portion that we are not able to separate it. So if you apply the same thing to the laws, exactly what doctrine of severability tells us, अगर ऐसा कोई law है जिसमें से one specific provision is what is violating fundamental rights, then we can remove that particular provision. और जो whole act है, like for instance, we will take the example of Information Technology Act in the Shreya Singh's case shortly. So what it says is, the whole act will not be invalid. Only that specific provision which is violating your fundamental right, we will try to remove that. That's a very logical thing to do, right? अब अगर कोई एक act है जिसमें 100 sections है, and there are 2 sections which are violating your fundamental rights, the logical thing would be to remove these 2 sections and not the entire act, right? You can't repeal the entire act on virtue of these 2 sections. At the same time, it goes ahead and tells us, but if your valid portion, for instance, अगर वो section इतना closely mixed है बाकी सारे section से, that if you remove that section, or the very fact that you are not able to remove it without altering the act, at that particular point, the court will declare the entire act void. So this is exactly what doctrine of severability tells us, that whenever you can sever a provision or whenever you can remove something which is violating fundamental rights, you try to do that first. If you're not able to do it, if that provision is so mixed or so closely mixed up or mingled with the other right which is valid or invalid, at that particular time you have to hold the entire act as void. So this was doctrine of severability. And to take an example of the recent 2015 case of Shreya Singhal, यहाँ पे भी exactly यही हुआ था. So there was section 66A, okay? As we are all aware, this section 66A has been struck down by the court now. This was the punishment for sending offensive messages through communication services, etc. Now, just because section 66A is violating my fundamental rights, will I remove or will I repeal the entire Information Technology Act is the question. What do you think the court did in this scenario? Would anybody like to answer? The question is, if section 66A, यहाँ तो पता चल गया हमको ये तो invalid है. This is something which is definitely violating my fundamental right. But because of this, will I remove or will I repeal the entire Information Technology Act of 2000 is the question.
Yes, in this case, the court struck down section 66A but kept the act.
Exactly. So यहाँ पे that's exactly how doctrine of severability works. It has been applied here. It has been applied in the Romesh Thapar case as well. What the court always does is, whatever provision or whatever section is violating our fundamental rights, they'll try to strike that down, and the other act, whichever act is in question at that particular point. For example, यहाँ पे Information Technology Act 2000 was in question. That act will not be struck down, because basically when you remove section 66A, the Information Technology Act is able to stand on its own. There is no part of the Information Technology Act which is now dependent on section 66A, for which you have to basically repeal the entire act. So here it's a good example where doctrine of severability was applied. let us take one small example again. This is the landmark judgment of A.K. Gopalan versus State of Madras. यहाँ पे question ये था that constitutional validity of Preventive Detention Act was in question, and section 14 and I think section 3 was also challenged specifically, that these are the sections which are violating a fundamental right. So what the court said, it's the similar reasoning which has been applied in Shreya Singhal as well, that section 14 is invalid, and at the same time the omission of section 14 from the act will not change the nature and the object of the act. This is very important because, as we discussed the example of the apple, had section 14 be so closely mixed with the other provisions that you cannot remove this section out of the act, then this entire act would have been held to be unconstitutional or invalid. But यहाँ पे the court gave out a very important point, that when we are removing this particular section 14, which in our opinion is definitely violating fundamental rights, the omission of the same from the act is not changing the nature and the object of the act. That is why you can remove that section and keep the act as it is. So that was it about the example of A.K. Gopalan. Now, if you all have any questions regarding doctrine of severability, we can discuss that. And even for doctrine of eclipse, if you have any question with respect to both of them, because these two are very, very simple topics, but it's very important to know because these are the doctrines, even if you don't consider it as something which is, applied very straightforwardly, this is definitely done in practicality in courts as well. If you see the case of Shreya Singhal, wahan pe bhi doctrine of severability was expressly applied, that you can remove section 66A, or for that matter the case of A.K. Gopalan, that you can remove that part and you can keep the remaining. So these are the two doctrines which are definitely used in the practical world as well.
Is there any difference between reading down a section and striking it down? Because I was thinking of the Aadhaar Act as well, in which certain provisions were read down. Would you say that the doctrine of severability applies there to the Aadhaar Act as well?
Which particular part are you talking about for according?
I think it's, I don't remember the section.
Part which you can sever. I think your question is that when you apply the doctrine of severability, does it go hand in hand with striking down a section, right?
Right. Or when you say you're reading down, is there a difference between the two when you read down and when you strike off?
So basically, striking down would apply. So doctrine of severability and striking down would go in hand, which was not the case with doctrine of eclipse, because doctrine of eclipse is specifically talking about enforcing a particular right, and if it is violating fundamental rights, then that law cannot be enforced. But doctrine of severability and striking down a provision goes hand in hand. If you see the example of Shreya Singhal, यहाँ पे this section 66A was struck down. At the same time, doctrine of severability was also applied. So while applying doctrine of severability, that is how they have struck down the section and not this. If you remember, section 69 was also challenged in the same case.
Yes.
But that section 69, basically the court said that is not violating your fundamental rights, but this particular section is. So they will strike that out by applying the doctrine of severability. So that does go hand in hand. As far as your reading down is concerned, I'm sorry, I've not read much about it, but I'm sure that striking down and severability, that goes hand in hand, because that's exactly how you apply the doctrine of severability.
When we have doctrine of basic structure, then does the basic structure prevail the doctrine of severability?
So I don't know in which situation would you think that these two doctrines are clashing. I don't think so. There won't be a situation wherein if you feel the doctrine of basic, whoever is asking this question, can you enlighten us with a situation wherein there would arise a contradiction between these two doctrines? Because basic structure is essentially that, this is the basic structure of the constitution, your Keshav Nanda Bharati case, basically, that you cannot alter the basic structure. And doctrine of severability basically says that, they are just going to remove a specific provision, which is violating fundamental right, and then we will move on and keep the other act in place. So according to me, there is no contradiction or conjuncture wherein you have to choose between the two. If there's a specific situation you would like to ask about, we can discuss that then.
The participant is saying basic structure can also hold a law void or challenge it, and that goes for this doctrine as well.
So exactly, so it's going side by side, right? Agar basic structure, if by virtue of that, if something is getting or if something you feel that it is violating a fundamental right and you're striking it down, then doctrine of severability can in fact work side by side, that you can remove a particular part which is violating the basic structure as well as keep the other. So there is no contradiction at any juncture. You can apply both of them together as well.
Any example in severability where the entire act was repealed?
In fact, yes, I think I don't remember the case, but it was basically an entire act. It was said that we can't. It was, I think, preventive detention, not preventive detention. It was regarding a parliamentary order or something. I will, if you all have a list of these participants, I can send that case to you. I was just reading it yesterday. So basically,
Okay.
वहाँ पे the court said that because the act or the provision which we are talking about is so interlinked and so mingled with each other, we are going to basically remove the entire act. So the entire act in that case was said to be unconstitutional. So that is your Apple example wherein you were not able to sever any part out of it. So there are cases, to answer your question, there are cases wherein the entire act has been held to be invalid because they were not able to sever a particular part out of it. And I think I just read about the doctrine of reading down, which Deepa Madam was asking. So I think that's a very separate thing. So because it says a legislature uses same expression in the same statute at two places or more, then the same interpretation should be given to the expression unless the context otherwise requires. So that is basically, I think, a rule of interpretation and not, wherein you remove a part or repeal. It's not talking about that at all. It's basically interpretation of statutes.
Even non-citizens have fundamental rights. So to what extent are these doctrines applicable towards them?
So basically, your fundamental rights, which are for all persons, wherein you say all persons have so and so right. So basically, the fundamental rights have also been, when we talk about the constitution, it talks about three categories of people, right? Ek to alien ho gaya, ek persons and ek citizen. So citizen is the one which basically has the most of the fundamental rights because it is included in the other two classes. And all persons may. So the thing is, this classification nowhere determines that, whether this doctrine will be applicable to you or not. The very fact, if a fundamental right is applicable to you, okay, the question which you always have to answer is, logically, even if you're not applying the doctrine, is this fundamental right available to you? If I am, for example, not a citizen of India, and if I come under the category of all persons, there are certain fundamental rights which are applicable to me as well, right? So if that right has been violated, I have the remedy under Article 32 or Article 226 to go and enforce my fundamental right. So in that case, if the right is applicable to me, then the doctrine would also be applicable by the court. Because if you see, jo persons ka right hai, that will also be, the citizens are also included in that, right? So at any point, the right of the citizen will also be considered at that point, because this is basically a class of people who citizens basically has all the rights whichever is mentioned, unless expressly it is said it's not given to a particular citizen, right? So all persons, in fact, is the class which is after the citizen. So any which ways, if a right has been violating and if you have the fundamental right, there won't be any discrimination that you are person, so isme nahi tumhare ko hum doctrine apply karenge, or if you are citizen, we'll apply it in a better manner. That won't be the case. The only question is whether the fundamental right is available to you or not, and whether can you enforce it in the court of law.
Reading down is one of the tools of interpretation, but it is done for the similar reason that the entire statute is not declared unconstitutional.
Right, so that is what I was saying. So that is basically you apply a doctrine. It's not basically a doctrine. It is basically the principle of reading down, which is one of the interpretation of statutes principle, wherein you say if I am able to interpret in a manner wherein I can save the provision, the judges, basically this is the interpretation principle for the courts. The judges would read down that section in a manner wherein you can save the provision from it being void. Because obviously, logically, if you apply all these three things together, why do we do it? Because unnecessarily हमको ना laws या provisions को repeal नहीं कराना है, because when these laws were put in place, they were done after a very long, the whole lawmaking procedure. So you always assume there's a presumption of constitutionality of all the laws, right? Agar if I have to say that this, like for instance in the Shreya Singhal case, if I want to say that this law is invalid, it is I who have to prove that this is invalid. The state government won't say कि यार ये valid है. So you always have a presumption of constitutionality, and that is how the reading down principle. So if you do apply that together, like Deepa Madam said, so it will go hand in hand, that you are trying to save a provision while reading it down, and the doctrine of severability would be one step further when you apply the doctrine and you try to remove that particular section. So all of them, as I said, there is no contradiction between them. Even the doctrine of basic structure, for example, all of them can very well go together, unless there's a specific situation jahan pe there is some some sort of contradiction happening, then the court would try and answer and remove that contradiction. Otherwise, I don't think so there would be any problem that, you can't apply reading down and severability together, for example. If I have to give you some concluding remarks regarding these doctrines, it would be that these two doctrines, a lot of times when we read about certain theoretical things, we assume that, this is something which is only going to help us with the LLB exams, which is not the case with doctrines such as severability and eclipse. If you see, they have been applied and they have been expressly mentioned in the judgments as well. So my concluding remark would be that, always try to approach any, not only just doctrines, approach any law in a manner which would also help you in the practical aspect as well, which is why I was very interested to deliver a lecture on this topic, because it is, since I have been dealing with the LLB subject of constitutional law, a lot of part of it is very theoretical, but there are specific, and in fact the part 3, the most controversial part, that is one part which is often used in the courts of law in our practical life as well. So yes, that was it. Thank you so much everybody who was part of the session, and thank you to the entire team of PLEA. It was great being here.